everyone. For those of you who don't know me, I'm Ranjit Khanna. I'm the director of the John Franke Humanities Institute, which is where you find yourself this evening. And today I'm very pleased to say a little bit about the occasion for this lecture, and then I'm going to invite our colleague Gabe Rosenberg to introduce our distinguished guest, Katherine Franke. So the Duke Human Rights Center has been a part of the Franklin Humanities Institute from very early on, from the mid-2000s. So just 4 or 5 years after the establishment of the Franklin Humanities Institute itself. And in those early days, there was some consideration of how it is that some various human rights centers have actually been established in conjunction with the humanities to try to understand both the sort of the philosophical and political background of the constitution of human rights, but also to understand the effect on literature of human rights, the effect of the literary on notions of the human, etc., and the kind of the conjunction of the conversations between the humanities and the field of human rights broadly conceived, which is very much the way in which the DHRC understands itself, this kind of broad conception of what human rights is, its relation to categories like social justice and other forms as well. And in those days, we talked to some of the people at places like Bard and UT Austin, where there's still a sort of ongoing conversation for some of us, where human rights and the humanities were really bound together in the conversations that were being formulated. And over the last few years, we have decided to have a lecture that is specifically bringing together people who are of interest for people, scholars and students in the humanities and in the human rights world more broadly. And so some examples of recent speakers in this series have been Joe Scott, Joseph Slaughter, one of your colleagues at Columbia, Tim Lovelace from the law school here, who is a historian of civil rights in the law school. And with that, I'm going to hand over to Gabe Rosenberg to introduce our distinguished guest. Thanks everyone for coming.
So it's my pleasure and honor to introduce the speaker tonight. Briefly, I'm Professor Gabriel Rosenberg. I teach in gender, sexuality, and feminist studies. I have a secondary appointment in history, and I'm actually trained as a legal and constitutional historian, which many people don't know about me, but that's true. A grad field. It is my honor to introduce the speaker, who is the James L. Dohr Professor of Law at Columbia University, where she also directs the Gender and Sexuality, the Center for Gender and Sexuality Law. She's also the founder and director of the Law, Rights, and Religion Project, which tracks the dynamic and sometimes contradictory relationships between emerging areas of civil rights law and both the legal and popular claims to religious freedom that now seem to be activated in response to them. This project is, of course, especially timely because of what might, at least at first blush, seem to be a historical reorientation between what we might describe as a liberal humanist dedication to rights-making as central to human flourishing, and, on the other hand, the use of rights claims to thwart claims to equality, also central to human flourishing. Now, put simply, rights-making once seemed to be the core domain of a liberal legal theory, a project pioneered, perhaps, by the Warren Court or Ronald Dworkin, depending on how you want to see it. But of late, rights-making is increasingly central to a variety of reactionary and inegalitarian political projects that, in fact, reject wholesale the premises of liberal legal theory. So are we now living in the very world that critics of rights-based legal strategies warned about all these years? That rights, when conceived of as supra-democratic instruments, could be redeployed so easily to conservative and anti-democratic political ends? Maybe. But this possibility would seem to step beyond even the worst fears of some of those critics. Gerald Rosenberg, or Uncle Jerry, as we called him. No, not really. No relation. His hollow hope, of course, only warned that rights-making courts would be thwarted by the more political branches of government, activated by a reactionary response. Today, constructive conservative rights-making is aimed explicitly at routing those other branches and insulating conservative policymakers from democratic oversight and democratic reactions. I think that's an important thing to consider, particularly as we think then about the work of our speaker, which offers a robust framework as well as historical contextualization to understand what's at stake in rights-making, particularly as the right is ever more enthusiastic about it. And none of this, by the way, I think would surprise anyone familiar with the jurisprudence of the Lochner Court. But broadly, Franke's scholarship queries both the theory and practice of legal rights making as it is intersected with transformations of gender, sexuality, race, and democratic citizenship, both in historical and contemporary America. Franke's work articulates a sometimes controversial skepticism of rights-making's ability to substantively ease the burdens imposed by entrenched forms of structural subordination, a position that in fact cuts to the very heart of law-focused strategies for social and political reform. Franke's first book, Wedlocked, NYU 2015, was authored in the midst of a series of, to many of us, astonishing legal victories that came on much faster than we would have predicted for gay rights advocates that culminated in the 2015 Supreme Court decision in Obergefell v. Hodges. A decision, of course, which established the right of same-sex couples to marry as fundamentally guaranteed by the 14th Amendment's due process and equal protection clauses. She observed that the struggle for same-sex marriage held important parallels to similar efforts to include newly freed slaves in the institution of marriage in the aftermath of the Civil War. In both cases, she observed that the institution in question performed an oppressive disciplining function at times, remaking the people brought into it along axes of racial and sexual inequality, often more than those people happened to transform the institution into engines for substantive equality. This approach is measured and rooted in an appreciation of the complex histories of both Reconstruction and the fight for gay marriage. It's impressive both as legal theory and I think as empirical historical work. Part of the skepticism, I suspect she would concede and may well concede in the talk if my predictions hold true, relates to the particular normalizing and disciplining aspects of marriage. Okay, so it's particular to marriage. But she also warns us against a broader idealization of rights writ large, especially if they are seen as legal tools capable of seamlessly trumping the relational, material, and institutional contexts that give rights, if and when they are valuable, their meaning, durability, and weight. This is perhaps less an argument against rights in a general sense, and more a seasoned appreciation for how legal instruments, and indeed rights as legal instruments, are deployed strategically in circumstances that are often overdetermined by material and structural factors. I take this to be a consistent lesson of all of her work, but particularly her second book, Repair, Redeeming the Promise of Abolition, from Haymarket Books in 2019, which makes a powerful affirmative case for reparations as a necessary response to the material debilities imposed on African Americans then and now by Reconstruction's failure, so that historical event and its long aftermath. Across this body of scholarship, rights-making must be understood not as a substitute for, solution to, or escape from politics. In a moment in which the relationship between rights-making and democratic process seems as fraught as ever, this observation, like all of her scholarship, remains an invaluable contribution to our understanding of how law functions and what the emerging meanings for democratic citizenship may be. So please join me in welcoming Professor Katherine Franke.
Wow, I think maybe I'll just take questions. That was really lovely. Thank you so much. I don't want to disappoint your expectations about what I'm going to talk about, so I need to rewrite my paper just a little bit in terms of your your introduction, but let me just say it's a delight, such a delight to be here. I'm almost a year late. I was meant to be here last March, and then the dreaded Rona, as the young people call it, got me and took me down for a bit. And so I'm just so happy to be here and not be sick, and wish the same upon all of you. Thank you so much, Ranji, for the wonderful introduction, Gabe as well, Robin for your leadership at the Human Rights Center, and Corin for all of the ways in which you've helped me get here and made it all the logistics so easy. These are new ideas, so I will defend them only so far, but mostly I'm just so delighted to be in an audience with an audience of smart people who can help me think through where they're worthy and where they could deserve greater thought. So I offer that just as an introduction to say that these are tentative thoughts and ones that I am honored to be able to share with you. So the new supermajority on the U.S. Supreme Court has shown itself more than willing to take up an aggressive constitutional agenda. That agenda amounts to revisiting and rewriting out of the Constitution well-established rights, such as the right to privacy, while at the same time doubling down on and robustly strengthening other constitutional protections such as religious liberty, free speech, and gun rights. This is an incredibly dynamic time for this court and for all of us, to be sure, but also an incredibly dynamic time for the Constitution itself. A facile explanation for this jurisprudential revolution is to say that the justices are implementing a conservative ideological agenda that's been in the making for 50 years. Well, that's certainly true, but I think the moment deserves more and deeper critical thought, and that's what I'm hoping to do with you today. There's something much more worrisome, I think, afoot here than mere political pendulum swinging. It's that deeper analysis of the role of the court in the project of modern democracy that I'd like to explore with you in this lecture. So when we look at the decisions from this court on abortion, affirmative action, COVID-related public health measures, gun rights, religious liberty, and free speech rights, to list only a few, there's a through line that is more, I think, than merely concluding conservatives won. What I think we're seeing is the constitutional entrenchment of an agenda that began at least 40 years ago. It's a project of transforming the idea of the public good and then privatizing it. This enterprise was premised upon a vision of the state that regards the exercise of public authority as primarily about facilitating the pursuit of purely private interests. For those underwriting this agenda, something we might call public interest or the public good, a raison d'etre for the state's very existence, is to be eviscerated, if not eliminated entirely. We can trace this agenda, of course, back to Ronald Reagan's presidency, which inaugurated a 40-year campaign of comprehensive deregulation of government functions. This initiative set its sights on the widespread privatization of large sectors of the economy, including functions that had been traditionally presumed to be essentially public in nature. Today, this deregulatory and privatization project is taken for granted as the state routinely delegates to private entities the jobs of providing public education, running prisons, and providing policing, water, electricity, and social welfare programs such as drug treatment, foster care, and housing the homeless. The goal of shrinking government as we know it struck many of us as radical 40 years ago, yet it's become normalized and even embraced by mainstream Democrats. Bill Clinton's and Barack Obama's presidencies were fully committed to this deregulatory approach to governance. Indeed, in ways that I think made Richard Nixon's presidency look quite progressive by comparison. So the Reagan policy agenda did not spring fully formed from the brain of Ronald Reagan. He was known more for being a gifted communicator than a sophisticated thinker. Rather, it was the work product of a well-funded, well-organized movement of business-oriented think tanks that treated the Reagan presidency as an opportunity to reconfigure the American economy entirely. This brain trust, made up of groups such as the Heritage Foundation, the Hoover Institution, the American Enterprise Institute, and others, thought big, had a long-term vision, and were successful in rolling out a step-by-step policy agenda that in due course became the new normal. What my talk today or tonight amounts to is a call for the left to invest in developing a similar long-term policy agenda that figures at its core a robust conception of the state, a state that holds compelling interests in protecting the common good. This agenda would rest on an embrace of something I want to call public secular morality. So let me step back and walk through what I mean with a particular focus on the role of the current Supreme Court as a central player in this deregulatory neoliberal project. So over the last 40 plus years, Congress and the White House, I think, took the lead in passing laws and regulations that divested the state from performing a wide range of traditionally public functions. The Supreme Court, to be sure, may have approved of these actions, but it wasn't a central player in reducing the footprint of the modern state. Now it's fair to say, with this new court, they are actively and centrally engaged in that project. What I want to do is unpack the meaning and impact of this new aggressive role now seized by the Supreme Court, diminishing the character and power of the state in American politics. I'll offer three fundamental insights. First, I'll argue that there is a forceful history and tradition of granting the state broad powers as custodian of a kind of public secular morality. I'll argue that there's ample Supreme Court precedent for the robust exercise of state power grounded in and justified by the promotion of the public good. Since the country's founding, this conception of public morality has been recognized by political leaders and the Supreme Court as providing the state with a compelling normative justification for the exercise of state power, even over the objections of religious and other dissenters. What we see in this history is the court aiming to create a flexible mechanism by which it can recognize the legitimate exercise of state power to protect and enforce the public good, while at the same time preserving a commitment to value pluralism in a complex society like ours. Next, that's the first point. Next, I'll argue that we're witnessing this new conservative court repudiating that history by eviscerating the state's power to promote the public good, by deconstitutionalizing the very idea of a public morality and the state's fundamental role in promoting or protecting public or collective welfare. In areas where the state has traditionally been granted broad plenary power to act in the interests of the public, we now see a court that privileges exclusively private interests and the rights of individuals to opt out of compliance with public norms they don't like. The court portrays the state as a threat to individual well-being rather than the custodian of the common good. As such, the state is left incapable of justifying its authority to act in the name of advancing what we call in law compelling state interests, especially when challenged by individuals who assert a right to be exempt from complying with public values they disagree with or object to. Whether it be in assuring the safety of public health during a deadly global pandemic or the equal rights and dignity of LGBT people. Either case, the court's treating the state as toothless. In this sense, the Supreme Court is not merely endorsing a congressional privatization project, rather it's now playing an active part in the project of privatization itself. not only of the economy, but of the concept of legitimate state power and authority entirely. So third, my last point, I'll suggest that the court is using cases involving religious liberty rights, challenges to COVID-related public health measures, and gun rights in order to solidify a new, robust constitutional right of withdrawal from collective community, a right of exit from a state that is considered to have failed. All of this points, in my view, to a need for a renewed commitment to the idea that the modern state should embrace the responsibility for promoting and protecting the public good, not just private interests. And that's where I'll end. So, first, James Madison wrote in 1788 in Federalist 45 that, I quote, "The public good, the real welfare of the great body of the people, is the supreme object to be pursued, and that no form of government, whatever, has any other value than as it may be fitted for the attainment of this object of furthering the public good." The year before, in Federalist 10, he took a deep dive into the threats to democratic government posed by capture of the state by faction, which he defined as a group united and actuated by some common impulse of passion or of interest, averse to the rights of other citizens or to the permanent aggregate interests of the community. That's Federalist 10. Preservation of popular governments required, in Madison's view, protecting against the forces of factions, or at least their effects, so as to preserve the exercise of state power in the service of larger, more collective interests, something he called the public good. The concept of public good then makes its way into the Declaration of Independence and Article 1 of the US Constitution, where congressional power is described as, "The Congress shall have the power to provide for the common defense and general welfare of the United States and its people." So the Supreme Court's early jurisprudence embraced a kind of Lockean conception of state power, because this all is the thinking of the US founders reflects that Lockean view. In a number of early 19th century opinions, the court observed that the authority of the state generally, and Congress specifically, lies in the common good exercised for universal purposes. And then in 1829, the court found that the right to govern, including the right of taxation, lies in a power which is given by the whole American people for their common good. Even property rights, in some respects the most fundamental of private rights, recognized in our political and constitutional traditions, must yield, the court said in 1851, when necessary to the common good and general welfare. So the court took further steps developing these ideas in the early 20th century with respect to the source and legitimacy of state power, reaffirming collective welfare as a foundational constitutional term and value. In 1902, when Reverend Henning Jacobson refused to comply with the state of Massachusetts' mandate that all adults be vaccinated for smallpox, not COVID, but smallpox, the Supreme Court rejected his objection and claim that he had a personal liberty right to refuse mandatory vaccination, and they upheld the state's power to mandate public health measures as part of a constitutionally recognized social compact to protect the common good. Social compact, an incredibly important term. The court wrote, "In the Constitution of Massachusetts, it was laid down as a fundamental principle of this social compact that the whole people covenants with each citizen and each citizen with the whole people, that all shall be governed by certain laws for the common good, and that government is instituted for that common good, for the protection, safety, prosperity, and happiness of the people." With Jacobson, we see a rich conception of public morality, one that is held by the notion of a social compact that has the welfare and flourishing of the citizens as its guiding principle. This principle gained even greater traction and substantive content in the court's mid-20th century jurisprudence. The 1954 Brown versus Board of Education decision deepened a jurisprudence of public morality and the threats posed by faction, particularly when that faction was grounded or anchored in white supremacy. Explaining the stakes in a case that asked the court to constitutionalize a right to non-racially segregated public education, Chief Justice Earl Warren wrote, "Today, education is perhaps the most important function of state and local governments. Compulsory school attendance laws and the great expenditures for education both demonstrate our recognition of the importance of education to our democratic society and to citizenship itself. It is the very foundation of good citizenship." Of course, in the aftermath of Brown, segregationists continued to resist the court's mandate that they not discriminate on the basis of race in education. And in a 1970 memo to President Nixon, his advisor, H.R. Bob Haldeman, who we might remember from other things, not this, urged the president to change IRS policy, tax policy, and punish schools that refused to abandon their racially discriminatory policies by revoking their nonprofit status. Haldeman wrote to Nixon, "Federal aid to schools deliberately segregated on racial grounds is wrong, constitutionally and morally, in my opinion." One doesn't often think of Haldeman as sort of a moral beacon of that period, but on this he was pretty good, right? Nixon followed Haldeman's advice and changed the tax code, saying that you could not retain your nonprofit status as a private educational institution if you didn't comply with Brown. Bob Jones University, a fundamentalist Christian school in Greenville, South Carolina, continued to engage in race discrimination in its admissions policies well into the 1980s. And the IRS revoked their tax exempt status. School didn't take this sitting down or lying down and filed a lawsuit challenging the IRS's aggressive position in forcing a public norm around race equality in education. The university argued that it had a religious liberty right based on a theology of segregation to retain their admission policies and tax-exempt status, both of them at once. The court disagreed and found that on occasion, this court has found certain government interests so compelling as to allow even regulations prohibiting religious-based conduct. The government interest at stake here is compelling. The government has a fundamental overriding interest in eradicating race discrimination in education. You lose your tax-exempt status because you violated a public norm. So in the 1980s, the state's legitimacy to enforce the public value of equality in the context of private clubs and their membership was tested in another line of cases involving the rights of clubs, private clubs, to exclude women and people of color. In a case challenging the JC's refusal to accept women as members, the court recognized the importance of private rights of association, but held that the state had a compelling interest in eradicating discrimination against its female citizens that justified the impact on the JCs and their male members. In these cases, the court was willing to trade off the judicially recognized right of association in favor of a governmental objective of making professional networking of opportunities available on a non-discriminatory basis. Now, of course, the law didn't do all the work here. And in these cases, the legal recognition of this form of authority for the exercise of state power was a response to a political moment, to an ethos in the larger society, one in which Americans endorsed a muscular role for the state in creating and maintaining a good and equal society. In a period of deep national divisions around the legitimacy and persistence of race-based apartheid in the United States and in US culture, the state was looked to. We asked the state to drag segregationists out of the 19th century and into the mid-20th century, often in the name of protecting public morality or the public good. These were recognized by the court as compelling state interests. This national consensus began to unravel, of course, in the mid-1980s, as a politics of deregulation, privatization, and privatization of traditional government functions took hold, and the shrinking of the state began, full stop. In his 8 years in office, Reagan effectively shifted the relationship of the people to their government by portraying the state as a threat to the public good and individual freedom. Early in his presidency, Reagan ended the Nixon-era federal policy denying tax-exempt status to racially segregated private schools. The Supreme Court, of course, had upheld that Nixon-era IRS policy on the grounds that the government had a fundamental, overriding, and compelling interest in eradicating race discrimination in education. And Reagan aggressively implemented a new approach to the role of government in dismantling race-based segregation, Jim Crow segregation in this country. Early in his presidency, he began to privatize a wide range of functions that had been traditionally understood as essentially public in nature and part of government's responsibility, providing for the poor, the homeless, those in need of drug treatment, domestic violence services, and even the running of prisons. In April of 1982, Reagan addressed a group of more than 100 religious leaders about his administration's efforts to have religious organizations and corporations step up and step up more in providing essential social services. The Reagan Revolution, or really that of the Heritage Foundation and their fellow travelers, successfully privatized not only significant parts of the economy, but also the domain of morality more generally. Lyndon Johnson's vision of a thick state, grounded in an idea of the Great Society, was fully repudiated by Reagan's commitment to a thin state that delegated values-driven work to the private sector, religious institutions, and Good Samaritans. Against this backdrop, we get, I think, better purchase on what the Supreme Court has been up to in this last decade. In important respects, the rise of constitutional religious liberty and gun rights could not have taken place, or at least not have taken place in the same way, without the hollowing out of the concept of public morality or public values. So let me turn just for a second to the writing of Alistair McIntyre on the idea of the common good and how it's useful. I think it's useful in understanding the new constitutional framework emerging from this new Supreme Court. For much of our constitutional history, the Supreme Court has engaged in a kind of interpretive humility, according to McIntyre, reaching what he describes as kind of temporary settlements in individual cases when values and rights come into conflict. Because failure to achieve settlement, he writes, would exact too high a price for the state to pay. For the most part, this approach had resulted in the past in the Supreme Court adopting a series of balancing tests that were used on a case-by-case basis by which the state's compelling interests on the one hand are balanced against individual rights to liberty, equality, and security on the other. This constitutional balancing was designed to be flexible and responsive to the values at stake in particular cases, thus cultivating an approach to constitutional rights and government interests that was nimble, provisional, and respectful of the notion that rights and state interests stand in a complex, synergistic relationship to one another, rather than in a static hierarchy or order of priority. All of this has now changed. All of it has changed. In a series of cases over the last 10 years, the Supreme Court has implemented a new approach to the legitimacy of the state's exercise of power. In important respects, we could see the start of this shift in the court's 2014 decision in Burwell versus Hobby Lobby, a case in which the owners of a chain of Hobby Lobby stores objected to the Affordable Care Act's requirement that employee health plans include coverage for contraceptives. The Obama administration justified the contraception mandate on the ground that it furthered important, indeed compelling, government interests in protecting public health and gender equality in the workplace. Thus, the case set up a face-off between, on the one hand, the private interests of evangelical Christian business owners who opposed both the use of contraception in any case and the conscription of private businesses to promote access to reproductive health care, and on the other hand, the public interests of gender equality and access to health care. Ordinarily, this is what we expected, ordinarily, in deciding a case like this, the court would have engaged in a kind of balancing, taking seriously the state's articulated interests in the common good and balancing them against the important rights to religious liberty and the right for a business to manage its own affairs. But that's not at all what happened. Instead, Justice Samuel Alito, writing for the majority, declared that they pay no mind to the state's interest in the public values of sex equality and protecting public health. Indeed, he wrote, "We find it unnecessary to adjudicate this issue." Rather, the important question was whether there were other means of assuring access to contraception for female employees of Hobby Lobby that did not require their employer to provide it through their company's health insurance policy. Justice Alito then went on to conjure a parallel public insurance scheme that did not exist, that was highly unworkable, and concluded that the mere possibility of this imagined scheme proved that the Affordable Care Act's goals could be accomplished by not involving a private company like Hobby Lobby. In other words, the compelling nature of the state's interest was of no concern to the court. Instead, they were interested in playing a game of gotcha. Second-guessing agency experts' judgment about how to implement the requirements of the Affordable Care Act and conjuring a truly unworkable alternative to the policies that these experts had put into place. This move made the case about how to protect business owners' private interests, thereby completely sidelining the Affordable Care Act's purpose, a purpose, it's worth noting, that was accomplished through a democratic process in Congress and through public notice and comment and participation with the Department of Health and Human Services. So what happens next? Antonin Scalia dies suddenly in 2016. Neil Gorsuch, not Merrick Garland, joins the court in his place. Anthony Kennedy then retires. We're still mad at him that he did this. And Brett Kavanaugh replaces him. With this solid, ultra-conservative majority on the court, the revolution begun in Hobby Lobby could take off without any lingering commitment by a majority of the court to the idea of the state's responsibility for promoting or protecting the public good. Then what happened? COVID. COVID provided a golden opportunity for the religious right to push the court and push the Constitution in a direction that elevated private religious values over the state's efforts to protect public health during a deadly pandemic. In March of 2020, governors and public health officials across the country scrambled to protect the population from a deadly new virus and implemented limits on in-person large gatherings, including religious services. The Catholic Archdiocese of Brooklyn challenged New York Governor Cuomo's order banning in-person religious services on the grounds that it violated their First Amendment rights to free exercise of religion. The Supreme Court agreed with them, and in a ruling issued only 6 months after the start of the pandemic, I mean, there's really not a whole lot of time here, they chose to substitute their own judgment about the need to limit in-person conduct, writing, "It has not been shown that elevating the religious liberty rights of the plaintiffs over larger public health interests will actually harm the public." They did this in the next sentence then saying, even though they are also not, the members of this court are not public health experts. So they felt fine substituting their own judgment in this context. One of the remarkable things about this Catholic Archdiocese case is that by the time it made its way to the Supreme Court, Governor Cuomo had already withdrawn the regulation that limited in-person religious gatherings. So the case was clearly moot. Yet the mere possibility of future restraints on private religious practice was so weighty in the eyes of Justice Alito and his colleagues that the court felt compelled to issue a ruling completely undermining the state's power to implement reasonable measures to protect public safety. At the time, reading these cases at home by myself, as we all were at that point during the pandemic, the court having gutted the state's authority to protect the public during this pandemic, I expressed in The Nation and several other places a deep concern. If the court can't find and sustain a compelling interest in protecting all of us from dying of COVID, any state interest in protecting access to abortion, LGBT rights, or racial equality just won't stand a chance. And indeed, they haven't. In case after case in the last 2 years, this court has been unable to identify, much less countenance, state authority to protect the public good when doing so may require the sacrifice of real or imagined private interests. The court's decision in the 2022 Bruin case is probably the most stark example, wherein Justice Thomas, writing for the majority, invalidated New York State's gun control law, a law that restricted the possession of handguns outside the home. Thomas insisted that the law violated the fundamental right to bear arms because it is not, as he wrote, consistent with this nation's historical tradition of firearms regulation. Rather than examining the facts and circumstances in New York that would lead my state legislature to decide they have a compelling reason to regulate the time, place, and manner of gun possession, the court instead required the state to affirmatively prove that its firearms regulation is part of the historical tradition that delimits the outer bounds of the right to bear and keep arms. Now, I want all of us to appreciate the shift in doctrine here. This is an important shift, and I know it's very lawyerly, but I'm hoping to do my best to explain it in a way that all of us can get our minds around. Ordinarily, in a case involving a fundamental right, Second Amendment, gun rights or fundamental rights, that is alleged to have been violated, the court might turn to this history and tradition idea and that test to determine whether history and tradition supports the right itself, the recognition of the right in the Constitution. This is what they did in Bowers versus Hardwick, the case challenging laws criminalizing same-sex sex or sodomy. And it's what they did the day after the Bruin decision in Dobbs, the case, the abortion case. And if what they argued in those two, Bowers and Dobbs, is that if there's a tradition of protecting this right, then the analysis moves on to whether the state has a compelling interest in protecting, in burdening that right. So is there a history and tradition of the right? If so, we will recognize it as a constitutional right, and then the state must come up with a very compelling reason for burdening that right, or the exercise of that right. Bruen flips the analysis entirely, forcing to the state, not the party asserting the right, but the state, to show a history and tradition of enacting laws that burden individual rights. The significance of this shift cannot and should not be overemphasized. With some claims of rights, religious liberty, gun rights, business interests especially, individual citizens merely need to raise their hand and claim a violation of some important private right or interest, and then a heavy burden is triggered and placed on the state to show a history and tradition of the exercise of this kind of regulatory power. Most importantly, the state is not asked or expected to come forward with a compelling public interest for acting the way it did. When you read the Bruen decision, there is no discussion at all of a compelling state interest in regulating handguns in New York City. I live in Harlem. Not the most dangerous neighborhood in the city, but I hear guns all the time now after Bruen in a way I never did before. So recall my concern that if the state doesn't have a compelling interest in protecting public health during a global pandemic, LGBT rights and other rights don't stand a chance. Well, my fears were borne out in the court's 2021 decision in City of Philadelphia versus Fulton. In this case, the City of Philadelphia contracted with Catholic Social Services to vet families as suitable to serve as foster parents. Given its religious beliefs, Catholic Social Services would only consider families made up of married heterosexual adults. They would not work with same-sex couples, married or otherwise, or anyone who is unmarried, regardless of their sexual orientation. Well, turns out that policy violated the City of Philadelphia's human rights law, their non-discrimination law, and so the city canceled the contract with them. They sued, Catholic Social Services sued, claiming that get this claim, that if it wasn't given an exemption from complying with the human rights law, it was being discriminated against on the basis of its religious beliefs. So what had been an accommodation before is now morphed into a discrimination claim. And the court agreed, finding that the city offers no compelling reason why it has a particular interest in denying an exception to Catholic Social Services while making exceptions available to others. They said this even though the city had never granted an exception to any other entity. But the fact that they might have or could in the future was enough. And the city indeed did argue that it had a compelling interest in preventing discrimination against LGBT citizens who wanted to serve as foster parents. Yet that interest carried no weight with the court. Indeed, it was not even mentioned by the majority. The fact that there was an important, compelling public value in prohibiting discrimination. So what we see with this current court is a radical departure from the historic moderation of temporary settlements that characterize the court's long-standing constitutional interpretive method. This court leaves no play in the joints for future cases in which the balancing of interests can take place in a kind of complex ecology in which the state's interest in protecting a kind of public morality or public good can be harmonized with private fundamental interests. Instead, what we see from this court is the issuance of inflexible and absolute rulings that elevate private rights over the public good, religious practice over public health, gun rights over public safety, free speech over LGBT rights, and that put the state on the defensive to justify any action, much less action that would have been previously easily regarded as a compelling in nature. So last observation I'd like to offer, and then I'd love your thoughts, about where the court is refiguring the relationship of the people to their state is this. It's worth noting that in the Roberts Court in their COVID cases, I mentioned only one to you, but there were several, they did not even cite Jacobson, that 1902 smallpox case, as relevant to the COVID cases. To me, to all of us, it seemed to be a controlling case, not even mentioned. Instead, it conjured the idea of an incompetent, muddled, overreaching state blundering in ways that tread on, or even might someday tread on, fundamental religious liberty rights. From Jacobson to the present, the story of the state told by the Supreme Court has come to mirror Ronald Reagan's words that I invoked earlier. Government is not the solution to our problem, government is the problem. Legal theorist at Georgetown Law School, Robin West, a legal philosopher, has made a similar observation about the court and its deregulatory impulses, particularly in cases involving gun rights, homeschooling, and she even extends it to same-sex marriage rights. As she frames it, what the court has created could be generically characterized, in her words, defensive rights of withdrawal, or in short, exit rights. A defensive right to withdraw is a right to withdraw from a social compact in order to defend oneself against state incompetence, where the state has basically breached, the individual is free to exit. Now, West wrote this in 2011 in response to the Supreme Court's gun control decision in District of Columbia versus Heller. That was an earlier case upholding, or case holding that prohibitions on handgun possession in the home. Remember, Bruin was about outside the home. This case Heller was about in the home for self-defense. Those regulations violated the Second Amendment in the court's view. I regularly assign West's article to my students now, along with the Bruin gun case. It's almost like the justices, and particularly Samuel Alito, read West's article and decided to use it as the animating idea of their decision in Bruin. In his concurrence in Bruin, Alito exclaimed that ordinary people who work at night must walk through dark and crime-infested streets to get home. Today, unfortunately, many Americans have good reason to fear that they will be victimized if they're unable to protect themselves by carrying a gun. West, I think, framed well what also animated Justice Thomas's long majority opinion. As she wrote it, the tragic rights of our age grant the citizen the right to withdraw from those bonds of citizenship, and they presuppose a state incapable of performing basic functions. One of the things to take, I think, from the Bruin case and from West's analysis of it is George Zimmerman has become the model of civic virtue in this new world order. So let me leave you with a plea for a robust reinvigoration of the notion of public morality that provides substantive content and justification for the social compact and the legitimate exercise of state power to promote that public morality. This would be both a political and a legal project, but more political, I think, than legal, but most assuredly a kind of culture work to resurrect a thick conception of the public good. I think it's a particularly important project now, as it seems very possible that we may acquire a kind of authoritarian, extremely authoritarian government in this country. So I have some more things to say, but I'm going to stop there because I've been talking too long. So let me just invite your questions. Thank you for listening. And I look forward to the conversation. You want me to just call in? Yes.
Yeah, we're recording. Yeah. Is it on? So thank you. I loved your talk. I followed every point, agree 100%. I might or might not forgive you for bringing me back to that Reagan nightmare.
You're of an age where he was important, right?
I went into mourning for several months after that election. My question is really, I really see the need for what you're talking about. My question is a little bit outside the terms of the talk and more about the vocabulary. that when we talk about, and this is something I've been puzzling over, when we talk about common good or public morality, who's deciding it, right? And this is, I'm curious if this is, if you're thinking about different terms or how, so my problem, I guess, or my dilemma is what happens when the common good sees the need for eugenics or camps? What happens if the common good is defined by a very different concept or government, right? So you're talking about a flip of emphasis, but a strong state may or may not be the solution to this. A strong state, as interpreted by the Warren Court, yes, but what if our strong state is headed by somebody that we don't even want to think about? So in other words, morality, common good, whose decision and whose interpretation?
Well, in a context in which the institutions of democratic governance are broken, which is where we are now, I believe, of course, that risk is not just possible, but real, right? That government will be seized and captured by what some, Madison and others, would describe as, and Locke as well, as faction. And I think that's what you're describing, is the capture of the power of government by faction, as opposed to a collective sense of what's in the well-being or the interests of all, or at least the least well off. Where I would have taken the discussion next is to the degree to which I find myself in uncomfortable company with some conservative thinkers, because they have been thinking about the common good very thickly for the last 10 years or so, or longer. Adrian Vermeule, who's a law professor, let's see, nice face, that's appropriate. Is a law professor at Harvard Law School who has actually written a book called Common Good Constitutionalism. Started out as an Atlantic article. And what he does is cite a lot of Aquinas, and then somehow ends up having his version of Catholic doctrine become the definition of the common good. And of course, the book has been widely criticized and critiqued for actually offering no logical justification, no careful argument for the substance of the common good that he comes up with. And ordinarily, the idea of public morality is something that is invoked by the likes of Lord Patrick Devlin, and people who condemn prostitution, sodomy, gambling, all sorts of bad, immoral behaviors. But there's no reason, I think, that we have to surrender the idea of the common good to that kind of Victorian or earlier sense of propriety or immorality. And yes, I think that's a risk. But I think the greater risk is that we on the left don't begin to articulate a competing vision of what the state can do. The left's investment in the conception of negative rights alone, and we have Ronald Dworkin to thank in large measure for this, has meant that we've collaborated in the project of the state being the problem. And we haven't invested in an idea of positive rights, of the state having affirmative obligations to take care of people, according to a sense of a common good that we would agree on. So yes, there is that risk. And because of that risk, I think the left has always walked away from the project. And look where we are. So I'm not saying that this is an easy thing to do and an obviously successful thing to do. It does come with risk. But not doing it, I think, is worse. Yeah. Okay.
So I'm really intrigued by withdrawal, and now I have to go read this Robin West article, which I clearly should have read long ago.
This is not an exam.
That's fine. I mean, let it be, please. It reminds me of the weird sort of arguments within constitutional law about secession in the mid-19th century. And so I'm kind of curious as to whether or not there's a way of reframing the concept of public good in light of an argument about unionism. And I say that in part because the argument for a constitutional basis for secession was used, of course, by Southern states and by the Confederacy writ large to withdraw from union. But it was also then, of course, used by the Free State of Jones. It was used by West Virginians. It was used by Unionists in upcountry Georgia.
Yeah.
It was used as a sort of basis for withdrawal or opting out of the political structures of the Confederacy and of those as well, which isn't, by the way, a suggestion that we should be valorizing secession, but it is to say that there was a certain sense in which that kind of constitutional argument could continually devolve down into ever finer levels of withdrawal, meeting a kind of like atomized individualistic sort of removal from the social contract. Mm-hmm. Is there an alternative kind of public morality that's rooted in what we might say is like a unionist constitutionalism that might also be accessible as a historical tradition that speaks outside maybe of what we think of as kind of conventional left sort of foundations?
That's interesting. It's an interesting question. You know, there's an active movement to have constitutional conventions again. We can do them anytime we want, to revisit the Constitution and consider amendments to it. And the Constitution doesn't have any prescribed process for doing this other than that it references these ideas of conventions. And there are a lot of very interesting people who are thinking about staging constitutional conventions in cities and other locations across the country where the people will come together in smaller groups to deliberate about what kind of constitution do we want? What is our idea of the common good? And that kind of deliberative civic exercise would strike me as possibly one way in which we could reinvigorate the idea of a kind of social compact and enfranchise people to feel like they have some part in it. I think part of why it hasn't happened is the fear that it will just get taken over by the bad guys because they're, quite honestly, better organized and funded than we are. But I know that the American Constitution Society and others have been talking about this for quite some time, and it strikes me as something that could kind of accomplish some of those ideas, so long as we control against having the bad guys not take it over. Yeah. Back in the back, yeah. Sir. It's okay.
Thank you for your provocative talk. Made me think, and
mission accomplished.
Yeah, and I'm not sure that I agree with you on everything. And I want to first. So one of the things that I thought I heard you saying was that the Good Samaritan notion of, hey, you should stop and help that person and not leave it, you know. It seemed like you were saying, oh, no, the government should be the ones taking care of people and not us acting as individuals taking care of the problem at hand. And did I misunderstand that? You seem to somehow...
I don't have a problem with the Good Samaritan. I have a problem with a vision of society that it is only the job of private charity. Usually religious
private charity
organizations.
and Good Samaritan is not necessarily an equivalent there.
No, but I was using Ronald Reagan's language. That's how he was framing it.
Yeah, and I mean, Ronald Reagan is bad for a number of reasons, but probably good for a couple of reasons too. I don't know which ones, but I'll give that possibility. And I think I'm a real free speech advocate, and that's where I'm more invested in, I guess, perhaps a 1960s era notion of trying to change hearts and minds of people, and that all of these other things can sort of go by the wayside so long as we've got a really vigorous opportunity for free expression and exchange of ideas, because we're not going to get to our nirvana without changing the minds and hearts of people who are the conservatives that you're speaking of. It's like, hey, why are they doing what they're doing? I'd like to think that it's for not just to get you, not, oh yeah, I want to, not power to what end? I mean, I guess maybe I don't understand that level of power hungriness, but I think it somehow is misguided understandings on their part, and the only way to get things better is really for really enforcing free speech. I think there's some not Supreme Court case, but the Bachelorette case where it really came down. It was a appellate level decision that really came down in favor of free speech trumping the possibility of racist intent on the part of producers, having never had a black contestant come up the ranks in the Bachelor series at that time.
I hadn't expected the Bachelor series to come up today, so well done, well played.
It's okay, yeah. Sure.
Maybe raise your voice at the end of a sentence so I can treat it as a question.
Yes. So do you not think that enforcing free speech rights is?
I think it's fundamentally important. Free speech is an
going to
essential part of a
ultimately,
democracy.
And I didn't hear you speak too much about free speech cases in there.
No, that's a different talk. But I will say that the Alliance Defending Freedom, which is the nonprofit legal organization, evangelical Christian legal organization that has underwritten a lot of these religious liberty cases, anti-trans, anti-gay, anti-abortion cases, they are so smart, very smart. And they've taken a strategy of morphing their religious liberty claims into free speech claims and kind of seeing the First Amendment holistically. And what they've forced the court to do is find, smuggle, invent an equality principle in the free speech clause of the First Amendment that is ingenious and horrible. The kind of equality rights that now, and this was the 303 creative case, the website design case that came down last term, where forcing somebody to comply with a law that says you can't discriminate in your business against people on the basis of their identity actually forces you to speak a message you don't agree with, right? And so free speech is a big concept. I think it's fundamentally important to the preservation of a democracy, but it also has its limits like any other right. No rights are absolute in my view. And that's to go back to this idea of temporary settlements, that what the court was doing with these balancing tests was having a tool that could appreciate the fundamental nature and importance of speech rights, not just for you, the speaker, but for all of us as a constitutional and civic value, yet say at some points those speech rights would have to yield to some other interest that is a competing interest at that time. Hate speech cases raise that issue, right? Sexual harassment cases raise that issue. We resolve it in situ, in the context where those issues arise, by saying, actually, in this moment, we have a more important value at stake. But that isn't to say that speech will always lose. It can come back another, as Ronald Dworkin would say, it can fight another day. But what this court is doing is actually tiering rights, creating some rights as higher and more fundamental, speech, religious liberty, gun, and property rights, and other rights are second-tier rights that always must yield when in conflict with those first-tier rights. This is a radical new way of thinking about constitutional rights, where they were always seen as in a kind of ecology with one another. Now they're in a status hierarchy. So I don't think anything I said today was that I don't value and treat as fundamental free speech rights, but it's a complicated constitutional value that needs to be seen and treated in the context in which one would want to raise it in relationship to other rights. I think you had your hand too. Yeah.
Hi, first of all, thank you so much for being here today. This was really incredible.
Thank you.
So I'm curious about the term compelling interest that you used a lot towards the end. And I'm curious.
In the beginning and the middle.
Well, yes, that is also true. But do you think that perhaps creating a stronger, more concrete, reworking the definition of what a compelling interest could be might help to reduce rejection of that claim from the Supreme Court, or do you think it lies more within the interpretation?
Excellent question. Supreme Court is usually unwilling to give concrete definition to something like what's compelling or what's fundamental, what's a fundamental right. Partly because they want to have a standard, not a rule. And in law school, we teach the difference between rules and standards, and I know we do that in other disciplines as well. And so these are standards that need to be sensitive to the context in which they're invoked. And would it be helpful to have a greater clarity in the definition of compelling? Probably, but I worry that the next case will come along that will rule out something that we hadn't foreseen. And I'm enough of a legal realist, meaning, and we all are, whether you know it or not, somebody who believes that law is basically politics, that no matter what standard you have, it will be used to further a particular political interest. So getting better at the language doesn't really solve that problem, but it's a terrific question. Glad you asked it.
Thanks.
Yeah.
Hey, thank you. So this is a sincere question. Let me think of how to phrase it. I'm wondering if you're addressing the left because they're your fellow travelers and you're saying, hey, we have to pay attention to this. But part of me is, one of my questions is just, are you really asking the left to be part of broader conversations that may already exist, because there is a great deal of critique of the state and of a lot of the apparatus of the state, I mean, particularly in academic circles. Mm-hmm. Or, I mean, why is your pitch not more towards claiming some of the social and political liberalism minus economic liberalism, or other centrists or other people in between, and, sort of seeing a broad-based sense of the common good, common weal?
It could be. It could be. I take that as a friendly amendment. And, I tend to, as many of us do, circulate in the company of people who call themselves progressives, and particularly right now see the state as a real problem. And perhaps I'm addressing the audience closest to me, but we don't win if we only talk to the people who already agree with us. And so I accept that as a friendly and thoughtful amendment. But you had a second part of your question.
No, not really. I mean, in some senses, some of what you may be saying, I guess, and I'm asking you, is a possibility, asking the left to amend some of its deep cynicism. Let me use a cynical kind of critique, perhaps, of the state, works that, draw on Foucault, or even turn to Carl Schmitt, or, Nietzschean sorts of views, or something else like that in that version of the left. And maybe what I'm asking you is, are you risking being seen as calling for a kind of social and political liberalism among the left, or how do you see the relationship between membership in the left or progressive left and embracing concepts? I mean, you went back to Madison. I mean, a lot of what you're embracing.
Not a progressive.
No, not a progressive, but you're embracing works that could be part of a kind of, again, social and political, not economic, liberal skeleton.
Mm-hmm. Mm-hmm. And I think that has been part of my challenge, not what I'm trying to do in this paper, but that I need to do, is to pour some substantive content into what the common good is, or what public morality might look like. That's not the yucky version. And to do that in a way that doesn't just reproduce a kind of Obama or Clintonian neoliberal negative rights vision of the state, or adopt Bernie Sanders's platform or someone like that. I think we need something more, something that looks forward rather than back. And that isn't actually my expertise and not what I'm trying to do here, but I do think the turn to the state is, as you say, a risky move for people of our ilk. And for that reason, I came to this meeting with some trepidation that I would get that pushback. It's partly because I'm an academic, but I'm also a lawyer and an activist, and I'm seeing what the right has done so effectively. And they're extremely good at developing very long-term strategy, and we're terrible at that. We're tacticians. We play whack-a-mole, and we mostly develop defensive tactical moves, and it just drives me crazy. I'm sure you too. So I'm trying to think more like they do, which is a kind of Schmittian thing, I guess. Maybe.
Thanks very much for your talk. It was really fascinating. And I have a follow-on question from Ara's. It may even just be another way of posing it. And because I don't think you're just calling on the left because they're the ones that you're familiar with. I mean, I think that another way of posing Ara's question is, what is the left at the moment,
yes.
right? Because I mean, not right, but correct. Because I mean, that's the other side of the question, right? The left that says keep the state out of my bedroom, or the left that says the tyranny of the majority claims secularism, but my religion can't be lived, or whatever. That is a liberal left that is pushing against. That's the liberals, I think, anyway, a liberal left who are pushing against the tyranny of the majority as well, right? And then, in some ways, are we sort of thinking about a kind of utilitarianism, right? When we're talking about the public good, So, there are all those kinds of problems, but in a sense, Marxists have never really, I mean, not never, okay, this is a completely stupid thing to say, I withdraw the never, but have always called for a stronger state. I mean, have frequently called for a stronger state, right?
How'd that work out?
So I think that there has to be some, if we don't actually stress the significance of what's stood in for the left, we actually stop seeing how liberals, like many of us, even if we'd like to claim some further left position, have been managed, right? I mean, we are managed into this position where by the larger system of neoliberalism to go along with thinking that our right for religious freedom, or whatever it may be, or the right to push the state out of the bedroom, or whatever it may be, is not a movement towards the right, but is a movement towards the left, right? So I mean, I suppose the question of the political more broadly, I suppose, is at stake there. But then also the question of how it is we're going to be thinking about what the left is that you're pushing for. Because certainly terrible things have been done in the name of utilitarianism. Certainly, liberal politics has often been the enemy of the left. Even if we weren't even if we weren't going the sort of the Schmittian line of a political theology, as it were, there's obviously a sort of an argument for a stronger understanding of how it is you have to push against the post-war nomos of the earth, which is in a sense understood as the beginnings of what will become neoliberalism by the time we get to the end of the 70s. So
yes.
Sorry, that wasn't a question.
No, but it was a thoughtful engagement. Right behind you.
Thank you so much. So I have a question. So you offered this, compelling history of sort of how we've constitutionally and as a country thought about the common good. But obviously, some of the times that you're referencing in that history were times in which women and people of color and other communities were very much not part of that consideration. Yeah. And of course, that has evolved, as you mentioned, of course, more recent cases before the Reagan administration. But do you feel like there's anyone that is articulating well kind of what that common good would be in the 21st century in terms of like where kind of all of our different communities are a part of that conversation and considered in that common good kind of term?
I do not. Okay. And I have been looking. And it's part of what made me want to do this, was to say this needs to be a project that we have surrendered to the likes of Adrian Vermeule and natural law scholars who have a traditional idea of immorality, that state job is to enforce a kind of morality that is not at all what I'm talking about. And the liberals and left, I think, have collaborated in that by identifying the state as the greatest threat to their freedom and equality as well. Which, you think of Black Lives Matter, it's not wrong. It's not wrong, but we need to think beyond a moment where the state is only violent and racist. Or we're left with Robin West's world of just exit. And that, to me, is not a sufficient answer. So politics, maybe not necessarily just the state, but politics is something we have to engage in. And, Alexandra Ocasio-Cortez is just not enough for me. And I'm thinking that she doesn't purport to be a theorist, but maybe you all, you are very learned people. You may know who those people are. I do not.
Thank you.
Yeah.
Sure. I mean, I'm sort of intrigued. This is less for the legal theoretical consideration, but more from a sort of historical perspective about our tendency to I don't know if this is that left problem we were just talking about, but yeah, who's this we and who's the our? But perhaps the tendency on the left to fight the last state. Mm-hmm. And it seems very acute and quite noticeable in moments. I'm thinking here that, the Agamben-esque sort of biopolitics crew entered into its its final stage of maturation in COVID to claim, this was the final moment of the state of exception coming into its full visibility, and then the American populace was kind of we'd really prefer not, and the state gave up on it, or at least the Supreme Court helped the state give up on it, right? Yeah. We didn't enter into a permanent state of exception, at least not in terms of what Agamben was explicitly predicting. Yeah. Is there a way out of this? Can we stop fighting the last manifestation of state violence and become more proactive in thinking about how to constitute a state that has abilities, how to put this, that are robustly pro-community while at the same time perhaps debilitating its violent capacities?
Yeah.
Can I add to that? Because I think I'm asking the same question, which is why aren't we talking about secularism?
I'm always talking.
Well, I know.
Yeah, I mean, I guess I wonder to what extent can we make that possible under conditions of late capitalism. I think capitalism builds a kind of violence into society that makes compassionate governance very difficult. And so maybe this is too difficult of a problem. I also am often drawn to Black futurism, the writing of Black futurists as providing a kind of thinking outside or beyond or ahead that I think the scholars you're describing are often looking backwards and fighting the last government. Although if you live in Florida, I think it feels like there's a good government right now to be fighting, or Texas. You don't have to look very far back. Well, socialism is a big term. I guess, we'll talk about what you mean by that. But yeah, there's certainly socialist components to what attracts me to the idea of a thicker, more normative state that takes the least well off as a central project of the state. But so sure. But I wouldn't want to return to that older thinking, but rather have a more forward-looking version of it. But yeah, mm-hmm. Yeah. I voted for Elizabeth Warren. Yeah, it's like sort of as compared to what? Anyway, thank you so much for coming.